Good afternoon. Welcome. Thank you for coming today. I think we're in for a wonderful program. I'm Roger Ream, president of the Fund for American Studies, TFAS as we call it. How many of you are in the TFAS program this summer? Good, good. Thank you for coming up to the Hill for this, or some of you are probably interning up here. We sponsor intern programs around the city in the summer and spring. We do programs for high school students around the country and a lot of programs for young professionals involved in public policy and government. So check out our programs at our website, dcinternships.org. This is the Capitol Hill Lecture Series we sponsor in partnership with Senator Rand Paul. It's funded by Steve and Nancy Einhorn and the Einhorn Family Foundation from Milwaukee, Wisconsin. They'll be with us next week on Wednesday for our lecture. It'll be Wednesday, not Thursday, at 12:30 in this room. So please join us. And our speaker will be Senator Rand Paul, so you won't want to miss that. Senator Paul is the junior senator from Kentucky, elected in 2010 and re-elected twice after that. He chairs the Committee on Homeland Security. Unlike some people who work in Congress, he had a real job before he ran for the Senate. He was an ophthalmologist in Kentucky. He had gone to Baylor and then Duke Medical School and realized our country needed help. And he really does believe there should be a presumption of liberty, that presumption of liberty was written into our founding documents, especially the Declaration of Independence and our Constitution, and you'll be hearing a lot about that today from our speaker. Let me just mention that when we're done, we'll be passing out lunch vouchers, so you can go down to the cafeteria and eat. So wait till we finish the lecture and you can get those from our staff. Also, after Randy Barnett finishes his talk, there'll be microphones here. Just raise your hand, we'll bring you a mic. Please identify who you are and where you go to school. So without further ado, Senator Rand Paul.
All right, welcome. Glad you could come. I'm excited to have the speaker today. I've gotten to know Randy Barnett over the years, and Roger mentioned the presumption of liberty. I think it's a wonderful debate, and he's got great books about it that whether you're in law school or not in law school, if you're interested really in the history of our country, but in the constitutional law history, that are definitely worth reading. Randy is a professor of constitutional law at Georgetown University Law Center. He's argued before the United States Supreme Court. He's tried murder cases as a prosecutor in Chicago and even portrayed a prosecutor in the feature film Inalienable. Does that mean you have like a union card, or? He doesn't know. He doesn't know. He's the author of numerous books, including Restoring the Lost Constitution, The Structure of Liberty, and Our Republican Constitution. He's currently working on a new book, Freedom and Flourishing, Libertarianism for the Real World. Today his talk is entitled, Why You Should Be an Originalist. Please join me in welcoming Randy Barnett.
Well, thank you, Senator. Thank you, Roger, for having me here again in this room with a really great-looking group of interns. My job here today, the Senator mentioned that I was in this science fiction movie, Inalienable, playing a prosecutor. That is actually one of the single thrills of my life. I've been able to try murder cases to juries in Chicago, argue in front of the U.S. Supreme Court, and play a prosecutor in a feature film. And if you want to see this feature film, you can actually watch it for free. It's available on YouTube. And I can tell you that it is not the greatest movie that's ever been made. It's just the greatest movie that's ever been made that I'm in. So it's the only movie I've ever been in. At any rate, here I'm going to talk about originalism today. So let me start with a show of hands about how many people have heard the word originalism. There, great. That's great. How many people think you know what originalism is? Good, good. You probably are wrong. You probably don't, because most law professors don't know what originalism is. So after you're done with today's talk, you will, in fact, know what originalism is, and you will therefore know what most law students do not, and certainly what most law professors who teach constitutional law also do not know. But before, sort of give me a sense of where you're coming from. Of the people that raised your hand, saying that you thought you knew what originalism is, could somebody raise their hand and volunteer to tell me what you think originalism is? I see a hand right over there, a brave guy right there.
My understanding is it's when it comes to law, it emphasizes the original intent of those who wrote the law and interpreted it. So if the Constitution, for example, it emphasizes how it was understood in the founding era.
Okay, it's actually a version of originalism. Any other idea? And by the way, I'm not here to dump on you if you get it wrong. I'm going to assume you get it wrong. I just want to get a sense of what you do know and what you don't know. Any others? Yes.
I've also heard original meaning, where it's what the common person at the time would have understood the words to mean after the law.
Okay, so that's an original intent originalism. This is original meaning, or sometimes original public meaning originalism. Yeah, those are two different flavors of originalism. That's correct. Any others? Okay. Well, let me just get into it then. I can tell you what originalism is in one sentence. That's why I'm going to tell you that you're going to know what originalism is after this talk, because I can give it to you in one sentence. Originalism is the view that the meaning of the Constitution should remain the same until it's properly changed by amendment. Now, I know you've probably heard originalism is a very controversial, very ideological, very maybe bad thing, maybe a really wonderful thing. But what I just said is really all originalism is. It sounds really pretty moderate. The meaning of the Constitution should remain the same until it's properly changed by amendment. Okay, so what's the big deal? Well, if we want to broaden out the frame a little bit, now that's it. That, by the way, is a full and complete accurate definition of what originalism is. But if we want to go a little bit deeper, we can say that originalism, we heard two different versions of originalism being articulated. One is framers' intent originalism. The other is public meaning originalism. These are two species or two examples of originalism. And one way to understand originalism, I think the best way to understand it, is not as a single theory, an individual theory, such as public meaning or framers' intent, and there's some others besides, but as a family of theories. And I say a family of theories because we know that if you're in a family, then you see certain similarities between members of the family. The family tends to look alike. There's differences as well. They're all not all alike, but they tend to look alike. And so originalism should not be thought of, I believe, as a single theory, but as a family of theories that share in common two claims. One is a descriptive claim about how language works, and the other is a normative claim about how constitutional actors ought to act. So let me take the descriptive claim first. The descriptive claim is that the way that language works is that meaning is fixed at the time a writing is adopted. The meaning of a writing is fixed at the time it's adopted. You see this uncontroversially in contract law, where if you sign a written contract, what contract law says, and if you go to law school and you take contract law, you're going to find out that the meaning of a contract is what's called the objective or reasonable meaning the contract has at the time of formation, at the time it was enacted, at the time it was entered into or executed. So the same claim is true of all writings of this kind, including the Constitution. I'm not saying the Constitution is a contract. I actually don't think the Constitution is a contract, but it is a writing. And writing is in language, and writings have certain properties. And the descriptive claim is that the meaning is fixed at the time it's enacted. So let me give you a couple examples out of the Constitution in which the meaning was fixed. But today we give those words a different meaning, and nobody would think that we ought to give the meaning of the words the meaning of the word that it has today, as opposed to the meaning it had when it was fixed. Let me take the first one, and that is the word dollar, which in the Seventh Amendment says you have a right to a civil jury trial in cases worth more than $20. So what was the meaning of the word dollar? Never thought of that, did you? I mean, nobody thinks about this. Well, what would the meaning of the word dollar be today? Today, it would refer to a Federal Reserve note. Open up your wallet, you're going to see Federal Reserve notes there. That's $1. You got $10, $5, $20, whatever you got there. Well, there was no Federal Reserve note then. There was just, what was there? There was no U.S. currency at the time the Constitution was enacted. So the term dollar could not have been a reference to a Federal Reserve note. here's what it was a reference to, and a little bit of historical research will reveal this. It was a reference to the Spanish silver dollar. The Spanish silver dollar was the most widely circulated currency or financial instrument in the world, and it consisted of a fixed quantity of silver. And so when the Americans adopted the $20 rule, they were referring to a quantity of silver equal to the Spanish silver dollar. And relatively soon after the formation of the country and the development of a Treasury Department, eventually the United States started minting their own dollars, their own silver dollars, which had roughly the same content of silver that the Spanish silver dollar had. But if you want to read the Constitution today and you think $20 means Federal Reserve note, you're just misreading what the meaning was and what the meaning really still is. It's the meaning that was fixed then. Here's another example. In the Constitution, it says that the president can call out the militia and go to the aid of governors in order to suppress domestic violence that arises, domestic violence. Now, if you heard the word domestic violence today does have a predominant meaning, and the predominant meaning is violence within a family or spouse abuse. Husbands beating wives, wives beating husbands, husbands beating children, whatever it is, today that is the predominant meaning. But that was not the meaning that was referred to at the time the Constitution was enacted. That meaning was civil disorder, civil unrest, riots in the streets. And so you weren't going to call out the militia to suppress spouse abuse. You were going to call out the militia to suppress riots in the streets. If you read the meaning of the words in the Constitution according to today's meaning, you're going to completely misread what the Constitution says, and nobody really does that. So these two examples of dollars and spouse and domestic violence are examples of what philosophers of language call linguistic drift. Linguistic drift. That words can change their meaning over time. But originalism claims that the meaning of the Constitution is the meaning it had, the meaning that was fixed in it when it was enacted before any such linguistic drift took place. And that means 1789, when the Constitution was enacted, 1791, when the Bill of Rights was adopted, or 1868, when the 14th Amendment was enacted. So it's whenever those provisions were enacted is what meaning was fixed there. Now, this is the first principle of originalism, and it is, I said, a descriptive principle. It's a claim about how language works. Now, like all claims, you could dispute that. To dispute this first proposition, which goes by the name of the fixation thesis, if those of you care about that, the label given this principle is called the fixation thesis. If you want to dispute this, you're going to have to come up with a view that says, well, that's not how language works. Language works this other way. And then you'd have to make that out. So any claim can be disputed. That's how you'd have to dispute that one. Okay, the second principle that defines the family of originalism is that constitutional actors ought to conform their conduct to the meaning that's fixed in the Constitution. Constitutional actors such as Senator Paul, President Trump, whoever you may, Chief Justice Roberts, they all ought to conform their conduct to the meaning that is fixed in the Constitution. Now, that is not a descriptive claim. That is what we call a normative claim. It's a claim about how people ought to act. And so to justify that, you have to have normative arguments on behalf of that view. And it turns out there are multiple normative arguments that you can have in favor of the view, in support of the view, that constitutional actors should conform their conduct to the meaning that's fixed in the Constitution. I'm just going to tell you about 5 of them, just going to tell you what they are. I'm not going to try to prove that they're correct, but I'm just going to, this is an informational, fact-finding lecture. The idea here is for you to come back from this lecture better informed about something that's really fundamental to political discourse today, which is originalism, than you were when you walked in the door. So here are 5 normative reasons in favor of saying that public officials ought to conform their conduct to the requirements that are fixed in the written Constitution. The first one is the rule of law, and that is the idea that the Constitution, the meaning to subject government officials to a rule of law in which they act consistently from case to case and over time, you need to bind them by law. You need to bind those who govern us by law. So one way to understand this, to appreciate this, is to realize that this is a copy of the Constitution here. This Constitution is not the law that governs us. This Constitution is the law that governs those who govern us. Those who govern us, they then make laws really close by here to govern us. But then the question is, what governs them? And the challenge is, how do you subject those who make laws to govern us with law themselves? How do you subject them to law? And the innovation of the American Revolution, of the American experience, was that you do that by adopting a written constitution that is then ratified in some way, shape, or form by the people. We come back to that if we have time. But nevertheless, nobody doubts that it is the Constitution. And that Constitution was not the product of then existing governments. It was not the product of the Congress of the United States. It was not the product of state legislatures in the 13 states. It was the product of a committee in Philadelphia that devised this Constitution, sent it to Congress, asking Congress to submit it to the states, where it would then be ratified by the people in conventions, not by state legislators. So this is not a Constitution that was the product of state governments. It was the product of the people of each state convening in conventions where they were chosen from their local communities to go into convention and decide whether they were going to ratify this document. And this document then would provide the law. This would then provide the law. This is the law that governs those who govern us. Now, this is only going to work if it's true that it has a fixed meaning. It only works if the fixation thesis is accurate as a claim. And it only works if it's something that public officials really can and ought to follow. So the reason why we say they ought to do it, the first reason we say they ought to do it is by subjecting them to law. You're subjecting them to a rule of law so that we are not governed by the arbitrary discretion of politicians or administrators, whoever they may be. So that's the first argument. The second argument, normative argument, has to do with the separation of powers. I assume this is a concept that many of you have heard. At the federal level, powers are separated according to the legislative power, the executive power, and the judicial power, in Articles 1, 2, and 3. And the separation of powers allocates the powers, including it allocates the power of amendment, the power of changing the Constitution. That's governed by Article 5. And Article 5 says that amendments you can make amendments, you can change this Constitution, but to change this Constitution, a supermajority of each House of Congress has to vote in favor of making the change. It's then sent to the states, where a supermajority either of conventions in the various states or of legislatures will then ratify what Congress has proposed. That is who is given the power to amend the Constitution under the separation of powers that is in the Constitution, that is specified in the Constitution. So if, for example, the Supreme Court should decide that the meaning of the Constitution should be updated to something that's better, something that's less retrograde than this old Constitution that we have, or if Congress should decide that, or if the President should decide that, they are stepping outside the separation of powers to do this. They are actually violating the separation of powers that's in the written Constitution, that's a fixed meaning. And that is something that we think is dangerous, because the Constitution separated powers precisely to protect the rights retained by the people, the rights that we have as individual citizens. That's one of the reasons why separation of powers was important. Okay, third reason, a normative argument for why government officials ought to follow the Constitution. They take an oath to follow the Constitution. Now, in contract law, if you consent to a contract, you're bound by the contract. You're only supposed to be bound by a contract if you consent to it. So if you go online and you want to download a program, you want to download something, before they let you download it, you usually have to check off a box. It's called a click agreement. You have to check off a box and say, I agree, to a whole bunch of complicated terms that you're never going to read. I'm a contracts professor, too. I don't read them either. I could justify this, but I'm not going to try. I'm just saying I don't. You're no better. I'm no better than you. But nevertheless, read it or don't read it. When you click that box, you are consenting to what goes on and what those terms are. Now, within limits, by the way, I should tell you as a contracts professor, but that's, again, a complication we don't get. But nevertheless, you are consenting to it. Well, how much more meaningful is it to take your hand, put it on a Bible or some other book, raise your hand and publicly swear that you are going to respect and follow the meaning of the Constitution? That is consent that's better than almost every contract has. That's, you go up to rent a car and you initial and sign and initial. I think taking the oath is even better consent than that. So there's the reason why public officials ought to follow the meaning of the Constitution. They promised to. They committed themselves to. And they only receive the powers that are created by the Constitution if they take the oath. So the powers that they're now going to exercise, they don't get to exercise unless they first promise to follow the Constitution. What Constitution are they promising to follow? I say they're promising to follow this Constitution. And what does this Constitution say? This Constitution says what was fixed at the time it was enacted. 1789, 1791, 1868, whenever it was enacted, that's the meaning they take. That's the meaning to which they swear they're going to uphold that meaning. Now, what would that oath consist of? What would its moral significance be if it meant, I hereby solemnly swear to uphold the meaning of this Constitution, whatever I say it is, whatever I or some other people here say it is, whatever we get together and decide what it is, including something better than what it was fixed at the time of enactment? Well, that would not be an oath at all. That would be an oath to nothing. It would be an oath to the air, because you'd be basically taking an oath to follow whatever you decide you wanted to follow. And that's not an oath. That defeats the whole purpose of an oath. Okay. Reason number 5 is a reason that actually is very popular, and I would assume that if pressed, many of you would articulate this as a reason as well, and it's one that I'm personally quite skeptical about. And I'm going to tell you what the reason is, and I'll tell you why I'm skeptical. And the reason is that we ought to follow the reading of this Constitution because we, the people, authoritatively enacted it. And whatever we, the people, as the sovereign, authoritatively enacted ought to be followed after that by people who are bound by the meaning of the Constitution. It's a very commonplace. It goes under the name of popular sovereignty. I do, by the way, think, and I'm going to explain to you why there are actually 2 competing conceptions of popular sovereignty, but this is the most popular one, the most well-known one. And so that is because a Democratic majority, or a majority of the people, because it wasn't unanimous, it was never unanimous. The Constitution was actually only, was very controversial at first and only barely got ratified. So it was by no means unanimous. They're the anti-federalists who opposed it. But whatever, when we the people, a majority of we the people at the time of the founding, and a supermajority of we the people through their legislatures during the amendment process, they've agreed to do this, and that's why we're bound to do this. Now, here's why I'm skeptical of this argument. Remember, this is supposed to be a normative argument, a moral argument for why we're bound by the Constitution, and why today members of Congress and the executive branch, they're all bound by the Constitution. It's supposed to be a normative reason. But the problem I have with it is I don't think consent really works this way. This is sometimes referred to as consent of the governed. But I don't think consent works in a majoritarian way, because if we have 2 people in a room, 3 people in the room and 2 people vote to take the property of the third person, you can't say, well, the third person consented to this because a majority ruled the other way. That's not the way consent works. For consent works, you actually have to be the one who consents. Remember I said click the box off? If somebody else clicks the box off, you didn't consent to that box clicking. You have to do it. And majority consent, assuming there even was majority consent at the time of the founding, is not going to bind the minority. Even then, it wouldn't have bound the minority, but if I'm right. My criticism of this theory is right. And then, of course, the familiar argument against this view of things, and that is that the founders did not represent a majority of the people at the time. The founders were all male. Most of them were probably property holders. although that's not necessarily true of the delegates to the conventions. But nevertheless, women were excluded from this process, free blacks were excluded from this process, and enslaved people and indentured servants, of which there were many, many thousands of them, they were excluded from this process. And so if you need a majority to justify popular sovereignty this way, then you don't get the majority then, and you certainly don't get the majority now when none of us have actually been asked for our consent to this agreement, or this contract, I'm sorry, it's not a contract, not an agreement, to this document that was enacted a long time ago. Okay, so it's a popular theory. I don't mean to, I only mean to show that I think it has some weaknesses. And if you put all your eggs in that theory, you're subject to the objections I've just made, these very familiar objections. Now, here's the fifth and final reason I'll offer to you today. It's the one that I like, in addition to numbers 1, 2, and 3, because none of these arguments are mutually exclusive. Let me just make a point about that. If you have to decide what you're going to do, what you ought to do, the more arguments you have in favor of doing that thing, the more confident you should be that it's the thing you ought to do. And so you don't just need one argument. One argument is great, one normative argument, rule of law. But 2 arguments is better. Rule of law, separation of powers. 3 arguments is even better. So rule of law, separation of powers, and the oath. Well, I'm going to give you another version of popular sovereignty that I actually think is the correct version of popular sovereignty, and it's reflected in the Declaration of Independence. And it is what I call individual popular sovereignty. And that is that a constitution is legitimate depending on what it says. And by the way, up till now, all of these arguments for legitimacy did not depend on what it says. It depends on how it was enacted and the fact that it provides a rule of law, et cetera, et cetera. And this argument is going to depend on what the Constitution says. And the argument is that the purpose of the Constitution is to secure the rights of we the people, each and every one of us. And this theory of government, this theory of the Constitution, is in the Declaration of Independence, where it says we hold these truths to be self-evident, that all men are created equal, that they are endowed by the Creator with certain inalienable rights, and to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. To secure these rights is the American theory of government. Which rights? The rights in the previous sentence, the rights to life, liberty, and the pursuit of happiness. What kinds of rights are those? Those are individual rights. They are the rights held by we the people, each and every one of us. Not a majority of we the people, not an aristocratic minority of we the people, but all of the people. And the legitimacy of the Constitution should be judged on the basis of whether, if it's properly followed, it is going to create a government that will be respectful of the rights of we the people and will not violate the rights of we the people. For example, by creating a bicameral legislature, having whatever 2 houses of Congress agree to send to a president for approval, or possibly a supermajoritarian override, and then being vetted by the courts to see if it was within the meaning of the Constitution to even enact it in the first place. All of these checks and balances built into the system, arguably, I would say yes, but we would just now arguably are there to protect the rights and to do effect, if they were followed, effectively protect the rights of we the people, each and every one of us. So this is another version of popular sovereignty, but it's not a version of rule by we the people, because that's actually not even what the Declaration says. The Declaration says governments are instituted among men. The Declaration distinguishes between the government and the rest of us. It doesn't assume the government is us. It says governments are instituted among men. Okay, before I open this up now to questions, let me just deal with the last part of the sentence, of that second sentence of the Declaration, which it says, those governments are instituted among men, deriving their just powers from the consent of the governed. Because a natural pushback against what I've just said is, doesn't the consent of the governed refer to the fourth argument, that popular sovereignty argument about we the people as a group deciding, what the law should be? I don't think that's really what it was about. This is my view. One can disagree with it. I think that's a view of which government is going to govern us. Is it going to be the government of Great Britain, or is it going to be the government of the United States? And this is a saying that we get to decide which government governs us. It is not a blank check that says whatever government we constitute speaks for us, and therefore we consent to whatever the government says on our behalf, which means basically the government can do whatever they want, because we can consent to almost anything if we're asked to. So that fourth argument, I think, does not work. It's not supported, I think, by the last part of the Declaration, that last sentence, which is really about something else. But this is what originalism is. It's a family of theories that basically makes a descriptive claim about how language works, and it offers multiple normative arguments for why that meaning should be binding on government officials. And I think if you could know all of that stuff as you walk out the door today, you'd probably know more about originalism than when you walked in. But in the meantime, I'm happy to take questions, comments, pushback. And there were supposed to be microphones. There are not microphones. Okay. Okay. Right here.
My name is Anthony Thomas.
And where are you from, Anthony?
I'm from
Montana.
Montana. I'm a student at Cornell University, and my question is, with sort of the Constitution ordering how the government ought to, treat government, what about corporations that, handle speech like X, Twitter, those sorts of things? Should they also, take steps to respect the Constitution and sort of about that?
Well, this is asking me about something that's not originalism at all. It's about the question for those of you who didn't. Everybody hear that? Everybody here? It has to do with what do you do about corporations that basically are the transmission vehicles for our speech, for example, social media platforms. You might also include cell phone companies in this, private companies in which you all speak and, they're controlling our means of speaking. This actually relates to the book the Senator mentioned that I'm currently writing, Freedom and Flourishing, Libertarianism for the Real World, in which I have a chapter devoted to private control of infrastructure that's necessary for us to be citizens as well as to exercise our liberty. And when I think a critical mass of this infrastructure is controlled by a handful of private entities, they end up being the same kind of choke points that government, it starts to rise to the same kind of dangers that we do recognize government would provide if they owned those means. And so at that point, I do think that gives rise to a right of access or a privilege of access. It doesn't mean that they have to give you the services for free, but it means they can't discriminate against you on a rational basis for exercising your liberty rights to use their platform. And I don't think it extends to all private companies, and it doesn't extend to all goods and services either. It does affect those particular nodes of interaction that we have with each other as citizens and as individuals that turn out to be owned by private companies or non-government institutions, but have their power to exclude becomes almost as serious, if not as serious, as a practical matter to the power to imprison you for doing something. The banking system is another good example of this. If you get debanked and no bank will deal with you in a world of 3 major international conglomerate banks that we have and not a whole bunch of local banks where you can walk across the street to another bank and you're not allowed to have a checking account or a bank account, you might not be able to get a job because that's how you're going to get paid. That's another possible stranglehold you have on liberty, and I think libertarians need to take this seriously. But I have to say, up until now, they don't really take it seriously, and so my book is going to be an attempt to bring them up to speed on this, but that hasn't happened yet. So I don't expect agreement from those of you who identify as libertarians in the room. By the time you're finished reading my next book, I assume you'll agree with me, but I haven't finished writing it yet, so you can't have read it. How about right there? Yeah, you. Yep. Yes. Sorry. Where are you from? Oh, I'm originally from Chicago myself, so Calumet City to be more precise. Calumet City, which is south of Chicago, but my family's all from Chicago. Go Bears.
So my question for you is with regards to the Supreme Court decisions in recent years with regards that based their decision on originalism. And I thought it was interesting the definition you gave about, for example, the dollar example, and how the Supreme Court attempted to apply originalism, and the words and their definition and the one you just gave seems to contradict. For example, with regards to the word arms or militia, the way our founders would have understood arms is significantly different from the way we here today would understand the word arms. For example, the founding fathers who wrote this amendment have no idea what a machine gun is. They never did, because it was not invented. But in today's world, we have a different meaning of the word arms, and the Supreme Court used originalism to expand access to the Second Amendment, while also seeming to rely on a word whose definition has
That's great. Well, thank you for that question. It's a very helpful one because it allows me to talk about the level of generality at which the Constitution is worded. The Constitution is worded sometimes very, very specifically, and then sometimes it's worded very, very generally. And the reason why it's ruled specifically is because they thought that would be the only way to actually practically, meaningfully enforce that. So, for example, if they made the required age of the president to be, old enough to be mature, you have to be old enough to be mature. That's going to be very difficult to figure out what that means. If you say 35 years, everybody's going to know what you mean. So they figured on 35 years. If they say every state should have the right number of senators or the senators it deserves or something like that, that might be difficult. But if you say every state should have 2 senators, that's going to ensure equality in the Senate from states regardless of what their sizes are. Now, is the word arms a specific word or is it a more general word? Well, it's somewhere in between. And the meaning of that word has not changed, actually, over time, although it's potentially ambiguous in ways you didn't expect, you were not thinking of, because the word could mean weapons, which is what it does mean, or it could mean the limbs to which our hands are attached. That's an ambiguity in the words. Now, which is it? Is it limbs or is it weapons? Well, I think it's pretty clear it's overwhelmingly clear in context, both the context of the rest of the words in the Second Amendment and the context in which it was adopted, that they meant weapons. Now, within that category of weapons, did they specify which weapons? No, they did not, because they understood, as well as we do, that the technology of weapons can develop over the years. It had developed. They may not have been completely familiar with what you call a machine gun, which is a fully automatic weapon, but they were actually familiar with weapons that held multiple rounds, between 20 and 25 rounds. They didn't just have muskets there. They had air rifles that could fire many more rounds than that. The more you know about guns, the more you realize that the guns, even at the time, were very diverse. But the basic point here is that it's weapons, including firearms, in case there was any doubt about that, that are protected by the Second Amendment. And so that is the originalist answer. Now, this brings me to one distinction that I did not make, which is a distinction that, this is a little more advanced. We're getting more advanced here. And the distinction here is between interpretation of the meaning of the text and construction or application of the meaning of the text to particular cases. This is going to turn out to be a very fundamental distinction, which you really should know, and I would probably be negligent if I let you walk out without knowing what this was. So on the one hand, the act of interpretation, the activity of interpretation, is to figure out what was the meaning that was fixed at the time this document was enacted. And I'm claiming, and you're free to dispute this, I'm claiming that the meaning of the word arms was weapons, and that meaning of the word weapons clearly included firearms, in addition to edge weapons, which are swords and other types of weapons as well, not just firearms. So that's the meaning. But now you have to implement the meaning. You can apply the meaning to particular cases. Should guns that carry more than 10 rounds be included? Guns that are fully automatic? Guns that are semi-automatic? You all, of course, know the difference between a fully automatic and a semi-automatic. I'm sure you do. A fully automatic is if you pull the trigger, bullets keep firing like on TV. That's sometimes called a machine gun. A semi-automatic is for every pull of the trigger, one shot comes out, and semi-automatic, it automatically rechambers another round, and you can pull the trigger again, but it's one shot at a time. That's semi-automatic. So can you do all that? Can you have everything? What can you have? How you apply the protection of the right to keep and bear arms to any particular kind of weaponry is the act of constitutional construction. And the way that we do constitutional construction generally is by adopting, the Supreme Court adopts something that's called doctrines or rules that are not in the Constitution, but are used to implement the Constitution. They're called, we call them implementing doctrines. The other name for this is constitutional law. If you take a constitutional law class, you're going to spend a very minor amount of time talking about the original meaning of the Constitution. You're going to spend most of when I teach it, I spend almost all my time talking about the doctrines the Supreme Court have come up with to implement the meaning of the Constitution. And so you've raised a very important question of implementation. Should machine guns, fully automatic weapons, be in or out? Should weapons that hold 30 rounds be in or out, et cetera, et cetera? I have my own favorite rule of construction that I favor as a gun rights activist and a gun owner and a concealed carry permit holder myself. I favor this rule of construction, but it is not the rule of construction that the courts have adopted, but it's the one I like best. And that is, I think one ought to be able to own any firearm when properly used in self-defense does not present an unreasonable risk of harm to innocent third parties. That is the rule of construction that I would adopt. It's not, unfortunately, not the rule that the Supreme Court has. Let me say it again. A firearm that, when properly used in self-defense, does not give rise to an unreasonable risk of harm to innocent third parties. I said, when you're trying to defend yourself using a particular kind of firearm, when using that is going to create hazards for third parties who are not involved. And I personally would put fully automatic weapons in that category because they have a tendency to spray. And that's not discriminating fire. You need discriminate fire in order to hit the target and not to hit an innocent third party. I would also put hunting rifles fired in self-defense in urban areas in this category because they are so powerful that they are likely to go through a target, into a wall, through another wall, and possibly into an innocent third party 2 houses away because they're so powerful. They're designed to kill game at a distance as opposed to be. So now I'm not saying that government should adopt any of these rules, policies. I'm just saying, to me, it would not be unconstitutional if they did, as a method of regulating the right to keep and bear arms. So that's the last thing I'm going to say in response to this. But this is why it was such a good question, because it enabled me to get into all of this stuff. I think that all liberty can be regulated. This is something libertarians shrink away from when you put it that way. But if you ask a libertarian, well, should freedom of contract be regulated by contract law? Do you have anything against contract law? No, I don't have anything against contract law. Well, that's a regulation of the making of contracts. I'm a contracts professor, as I mentioned. And so I think all liberties can be regulated, but the issue is that if to regulate them means to regulate the manner in which they are exercised, it is not to prohibit their exercise, which many opponents of gun rights want to do, nor to subvert their exercise, which many opponents of gun rights want to do. It is to make regular the use of, for example, and another example of something that I think is constitutional is concealed carry permits, which do the same thing that driver's permits do. In order, before you can operate a 2,000 or 3,000 pound vehicle at high speeds on public thoroughfares, you have to prove you know the rules of the road and you can handle a vehicle. That's a license. It's a way of exercising your right to operate a motor vehicle in the public. And I think when it comes to concealed carry of a dangerous weapon, and they're very dangerous, they're meant to be dangerous, they're designed to be dangerous, the idea that you would know the rules of the road with respect to the law governing legitimate firearm use, laws of armed self-defense, and the tort liability you have for misusing a gun, that's something you ought to know, and maybe you can demonstrate that you can actually handle a gun. But again, this is something legislatures don't have to implement. Constitutional carry states don't implement it. But it's permissible if legislature, it's not unconstitutional should they do so. And I say this as somebody, as an extremely strong proponent of the right to keep and bear arms, and I thank you again for that question. How are we doing on time? We got the handheld. How about time? Sure. How are we doing on time?
Yeah, we got 15 minutes.
How about right here?
Thank you. My name is Cindy. I'm from Texas, and I really appreciated you bringing up the interpretation versus construction. I'm a philosophy major. It's really good stuff. But I had a question about your rule number 3 of the oath when it comes to extrajudicial killings. For example, early in the year, whenever the Trump administration, the Secretary of War, had done airstrikes on alleged narco-terrorist boats off the coast of Venezuela. That was very interesting to me because it would seem as if that decision made by the general also under the Secretary of War would have violated the Constitution. But to relate this to your question or the question previously, I think we can all make the general claim that technology is it's outpacing how we interpret and also implement the law in this country, which has been generally the example, corporations that, control our language and guns being quite different nowadays. It seems like we are approaching a point where our Constitution is being violated over and over again, and people cannot do anything because of this idea of coercion, not consent. So on the international kind of stage, it seems like people are trying to implement this thing called international law, which is also controversial. And it seems like we can make this an analogy to your guns
Can we
argument.
get to the question?
Yes. Thank you for that. So basically, if our Constitution is not even preventing our own public servants from violating the Constitution, international law cannot hold someone accountable, and the international courts cannot hold someone accountable. If our country does not buy into those courts, how will we ever prevent things like extrajudicial killings?
Okay, well, I'm not going to answer your question because you could have an infinite variety of legal questions you want me to answer, and if I haven't given them systematic thought, I'm not going to provide a guess on my own part. Gun rights was a good question for me because I spent a lot of time on that particular topic. This one is not. But let me take issue, a little minor issue with one way you phrased this, because it's a very common way of phrasing it. And I think if you look at the news when controversies arise, you're going to see that I'm right. And that is that most of the time when the government is being accused of acting unconstitutionally, or when the president and the executive branch is being accused, especially when the president or the executive branch is being accused of acting unconstitutionally, the objection really is that they're acting illegally, in contrary to a statute of some kind. It's not usually that they're acting in a way that's demonstrably unconstitutional itself. And the reason why, before I have an opinion on any one of these dozens and dozens of issues that arise about whether the president has acted illegally or not, is to answer that question, you need to be familiar with the statutory authorities that Congress has given to the president. And for better or for worse, and I think largely it's been for the worse, Congress over its history has given, especially since World War II, has given the president enormous discretionary powers. Talk about gun laws. I mean, it's like giving the president just hundreds, thousands of loaded guns to be picked up and used at the president's discretion. And when the president picks it up and uses one of these weapons, these legislative weapons or powers that have been given to it by the Congress, then individual congressmen object. They, well, we don't like that. We don't like. Yeah, I know, but look at the statute. This is what happened here. Now, sometimes, of course, the president is acting illegally, is acting contrary. There is no legislative authority for what the president is doing, in which case the courts should, if they're doing their job, so hold when that particular thing is challenged. But most of the time, the president is invoking at least statutes that before you can have an opinion on whether the president is acting illegal or not, you need to familiarize yourself with those statutes. And the reason why I disclaim having opinions on most of these is I don't know these statutes myself, and I have not taken the time, especially when something new just pops up on the radar screen, to study them myself. So I listen to what other people say, and I kind of make a general assessment of who I respect, whose opinion I respect, and what they're saying about it. But I don't have a very firm opinion until I've looked at it myself. So the basic distinction I'm trying to urge upon you is that do not, when you hear in public discourse the president or some other member, it doesn't have to be the president, but nowadays it's usually the president, is acting unconstitutionally, the charge usually really is that they're acting illegally. They're not authorized to do it as a matter of law. And then to answer that question, you don't look to the Constitution. You look to the laws that either do exist or do not exist to authorize what the president has done. That's useful for evaluating the news. How about here? Yeah. Get the mic. And I'll come over to this side next. I think I've neglected this side.
Hello, my name's Sophie. I'm from Alaska, but I go to Georgetown as well.
Good.
Yes. I wanted to ask you, you described originalism.
Georgetown Law. You go to Georgetown Law or Georgetown University?
Georgetown University. I study public policy.
Okay. Right.
Not going to law school yet. Okay. But you described originalism as a descriptive claim about how the Constitution works. Has studying originalism changed your own views on what the Constitution ought to accomplish, or has it mainly changed how you think the judges should interpret it?
It's mainly the latter, the last thing you said. But I will say this. If you take the whole of my opening remarks seriously, originalism is neither a descriptive nor a normative argument. It's both. Because it consists of two principles, one of which is descriptive about how meaning works, and the other which is normative, is that how individuals in government ought to act with respect to what the Constitution says. So if anybody says originalism is a normative theory, in a way it is, but it's also a descriptive theory, but it's not merely a descriptive theory. And I think that originalism is, being an originalist has taught me a lot about the Constitution that I certainly didn't know about. And we constantly are being confronted with clauses of the Constitution with implications that we haven't thought of before. It's another reason why, as I get old, when I was your age, I knew everything, man. I had an opinion about everything, very, very confident. And the older I get, and the more I learn about any one thing, the less I feel I know about all the other stuff. And that's the reason why I end up not having an opinion about a lot of stuff, because I know what I know about what I know, but it just tells me there's a big gap between that and what I don't know. How about over there, the blue blazer?
Thank you. Excuse me. Thank you. My name is Price York. I'm from West Texas. I currently go to the University of Oklahoma College of Law. Before I ask my question, have you seen the ruling in U.S. v. Khomeini yet?
No.
Okay. It was 9-0 unanimous for the challenger about the law regarding illicit drug users having guns. So I just want to ask what your thoughts are on Bruin analysis and or how that analysis differs from other amendments, and whether that is consistent with originalism, or whether I guess we should focus more on a substantive due process and equal protections analysis on Second Amendment issues.
Well, you can tell that guy's gone to law school, because that's a question that none of the other. How many people here, by the way, are law students now? Okay. How many people have had constitutional law, either as an undergrad or law school? Okay. You're asking me a technical question about Bruin. I have an opinion about Bruin. I've published it. So I'm going to try to answer it briefly, but I just want you to know that when answering your question, I'm going to lose everybody else. I'm losing everybody. So Bruin it came out of a concealed carry permit regime that existed in New York, which was what we call a May issue regime, in which the government decided whether you deserved or whether you needed a gun or not to carry a gun outside the home. After the Heller case, you could have a gun inside the home, but if you wanted to carry it outside the home, in Bruin, in New York and California and 5 other states, by this time they were the outliers, you could only get a permit to carry outside the home if the government thought you needed one, and it was up to the government to decide if you did. And so the issue is whether that's an unconstitutional restriction on the right to keep and bear arms. I think it quite easily was such a restriction, quite demonstrably was, because it basically said you don't have a right. The government has a privilege to tell you whether you can have it or not. That's not a right. That's the opposite of a right. I already told you I think that right can be regulated, as it is in the case of concealed carry permits, which I hold. But prohibiting it altogether, or a regulation is you meet all the requirements of the regulation, you get the permit. You have a right to it, as opposed to we'll tell you whether you need it or not. That's what Bruin knocked down. But the court in Bruin was faced with the problem, and that after the Heller case in 2006 and the McDonnell case in 2010, which upheld the right to keep and bear arms as an individual right applicable to the states, after all that, many lower courts, circuit courts, were engaged in what you might call judicial civil disobedience against protecting that right from increasingly restrictive gun laws in certain states, and they were letting them all pass. So the Supreme Court, after a hiatus of 14 years, they finally decided they would give additional guidance to the lower courts to try to restrain the lower courts from upholding every conceivable gun law that they might hear. And so they came up with the historical analogs test. And the historical analogs test says government can regulate a right if there was a comparable regulation that existed at the time the right was enacted, which is at the time of the founding. So if you can't find what was called a historical analog, or a regulation that was analogous, closely resembling the regulation you have now, if you can't find that back then you can't do it at all. And I think that's a rule of construction. I'm glad I already told you what the interpretation construction distinction was. It's a rule of construction. The fact that it was made up by the court is not an objection to it. All rules of construction are made up by the court. The question is it a faithful or good rule or a bad rule? It was a rule meant to be very restrictive. And as a gun rights advocate, I kind of like that part about it. But I think it was a bad rule for a couple of reasons, so I'm not in favor of it. The number one reason I'm not in favor of it is because the mere fact that the legislatures did not exercise the power at the time of the founding does not mean they didn't have that power. And Bruin depends entirely on the fact that they did or did not exercise that power. If they didn't exercise it, then we say they didn't have the power in the first place. That doesn't really follow. You could have the power and not feel the need to exercise it until later. So there's that problem with it. There's also the problem that in the case of Bruin itself, they didn't even apply their own standard to shall issue regimes, which they said are perfectly fine. The kind of regime in Florida or the District of Columbia, these are shall issue regimes. That is, if you meet the requirements, you shall get the permit. Well, there's no historical analog for that either. There were no such regimes before the 20th century. And so the idea, I mean, so that actually, the regime, that the form of regulation they said that we are not touching, that we think is okay, is the kind that wouldn't have passed their own test if they'd applied it. So I think it's problematic. Now, there is one footnote in Bruin that I do kind of like. The opinion was by Justice Thomas, who I admire. He's probably my favorite justice. So I'm disagreeing with my favorite justice. But there is a footnote in there where he says even shall issue regimes might be unconstitutional if they become abusive. That's right. That's exactly right. Shall issue regimes can become abusive. I think the shall issue regime in the District of Columbia is abusive. I'm not going to go into the reasons for it. But I think in that case, if it becomes abusive, it's the court's duty to say that this is probably a pretext. This law is probably a way of just discouraging the exercise of a right, which is not a legitimate government function to discourage your exercise of your rights. So I'm a skeptic about Bruin. But Bruin is what we have, and Bruin, as you know, was sort of loosened up in this subsequent case called Rahimi, in which we look for the principle involved in previous regulations. But I think by and large, the court is sort of barking up the wrong alley. Barking up the wrong alley? I'm missing metaphors here. They're barking up the wrong tree. Yeah. Don't want to mix my metaphors. Okay. This has to be the last question, and it has to be quick. Thank you, Senator. Go ahead.
What do you do as an originalist if you have not just the original meaning, but the meaning in multiple interpretations? Like the 14th Amendment has been referenced in so many different Supreme Court cases. It was very infamously used in Plessy v. Ferguson to justify Jim Crow, and then overturned that interpretation in Board versus Education. So like you have not just like the original meaning, but this long history of contradictions of like how to interpret that. What do you do with that?
Okay, one of the most fundamental problems, challenges for all originalists is the doctrine of precedent, or stare decisis. Stare decisis is Latin for it shall remain the same. A precedent is another word for it. If there's precedent that is inconsistent with the original meaning of the text, what do courts do about it? That's a major fault line amongst originalists. There's disagreements about how much you should reverse precedent or not. So it's a very good question. I am somebody who thinks precedent does have some value. But I do think that the Supreme Court, including those on the court who identify as originalists, are far too deferential to precedent that was not decided on originalist grounds and is inconsistent with original meaning, and they should be more skeptical, and they should be more critical, and be more receptive to challenges to those laws than they currently are. But it's a big question. It's a complicated question. There's no easy answer to it. But I just want to acknowledge that is one. I'm very glad you asked this question, because it is a fundamental challenge, not just to originalism, but to any theory of constitutional interpretation. No matter what your theory of constitutional interpretation is, what do you propose doing about misguided precedents that go contrary to whatever your theory is? And there are going to be difficult cases in which that's not going to be an easy case for anybody to decide, except the person who says the Supreme Court should do what I want it to do when I want it to do, and it should not do it when I don't want it to do it. And that's my principle of interpretation, what I like. And that's really not a theory of interpretation at all. So anyway, thank you very much. Enjoy the rest of your summer. Thanks.
Thank you, Randy. That was great. Can you stay for a few minutes?
Sure.
Talk informally. And please don't forget to pick up your voucher. Hopefully we'll see you next Wednesday at 12:30 with Senator Rand Paul.